Доброго дня.
Добрий день.
Добрий день, шановні учасники заходу.
Morning, dear participants. We shall commence. A very warm welcome to the Ombudsman Secretariat. My name is Alexander Marchenko. I am a member of the Secretariat of the Ombudsman, and I lead a unit that is responsible for personal data protection in Ukraine. I'll be one of the moderators for this event, and later I will talk about the Ombudsman's recommendations on personal data protection in the healthcare sector. We will start with welcome remarks, and I would like to give the floor to Deputy Head of the Council of Europe Office in Ukraine, Mr. Ellen Falk.
Thank you so much for that, Mr. Machenko, dear Mr. Pankov, dear all participants, representatives of public authorities, expert societies. First of all, a very good morning to all of you. It's really a pleasure for me to be here today to the presentation of a report that from the Council of Europe side we see as very important. This analytical report on the compliance of the Ukrainian healthcare system with data protection standards. We are also happy that the report is the result of a joint work between the Council of Europe office and the Parliament Commissioner for Human Rights. This is a cooperation we always appreciate very much. The goal of this report is to address some of the complexities of data processing and protection of patients' rights in the healthcare industry in the digital era. So I started out by saying that from the Council of Europe side, we see this as an important report, and I wanted to say a few words about why we think so and what makes this an important topic. So as you will know, the Council of Europe and the European Union have revised our personal data protection legislation several years ago now. So the Council of Europe's Convention 108 and the EU General Data Protection Regulations are two frameworks that provide very comprehensive guidelines for the protection of personal data. An important goal of these regulations is to balance, on the one hand, the need for efficient healthcare delivery, with, on the other hand, the fundamental right for privacy. And for that reason, Ukraine, as both a member state of the Council of Europe and now an associate member of the EU, needs to bring its national legislation, national practices in line with the requirements and standards set out by the Council of Europe Convention, by the EU documents, as well as with the case law of the European Court of Human Rights and the Court of Justice of the European Union. I think it's also important to highlight here that while reforms in the field of personal data protection are quite complex, they also come with many benefits for both people and businesses. And I would like to take the opportunity here to draw your attention to the need for Ukraine to ratify the protocol amending Convention 108. So that's the protocol on the protection of individuals regarding automatic processing of personal data. The revised provisions of the convention comes with quite significant updates to the guarantees, taking into account all challenges that currently exist in the field of personal data protection. So coming back to today's discussion, I also want to emphasize that data protection is an essential issue in the healthcare system particularly, by ensuring confidentiality, integrity and security of patients' information. So proper management of personal data is crucial, not only for maintaining patients' trust, but also for enhancing the quality of patient care. This also involves protecting sensitive information from unauthorized access and misuse, while at the same time ensuring compliance with both legal and also ethical standards. So with that as a background, during today's presentation, we will look at how data protection is currently handled by the Ukrainian healthcare system. We will look at some of the challenges this system has faced, and we will also discuss how these challenges can be overcome with due reference to the European data protection standards. So just to round off from my side, I would just like to repeat that the Council of Europe very much stands ready to support Ukraine in all really progressive initiatives of Ukrainian public authorities and specifically to the Ombudsperson's office as regards the implementation of data protection reforms. So thank you very much. I'm very much looking forward to the presentation of the report.
Дякуємо за ваш виступ.
Thank you for your remarks. Unfortunately, Mr. Dmytro Lubinets, the Ombudsman, could not be present at this event today due to urgent business that require his presence. Therefore, we would like to give the floor to the head of the Department for United Parliament's Commissioner for Human Rights, Mr. Andrei Pankov. Morning, dear participants. Today, we discuss an extremely relevant and urgent topic, namely data protection in the healthcare. The mounting amount of data proves the data confidentiality is essential. Losing patient information or unauthorized access thereto might have very grave consequences. The Ombudsman Secretariat thanks the Council of Europe office in Ukraine for their activities in enhancing data protection in Ukraine. Also, within the framework of the Council of Europe program supporting implementation in the European human rights standards in Ukraine, and as part of that program, Irina Synuta, the expert, put together a presentation, and Irina will share her view, and later she will present today the outcomes of this report. Also, we would like to present the recommendations of the Ombudsman on personal data protection during the data processing in the field of healthcare. And the outcomes of checks carried out by the Ombudsman's office paved the way to drafting these recommendations. Alexander Marchenko will report on that because his unit is tasked with this field. Thank you for listening, and I look forward to substantial discussions. Thank you. Thank you, Mr. Pankov. Now, I suggest that we listen to the analytical study findings, and we give the floor to the Council of Europe experts, Irina Synuta. Thank you, Alexander. Distinguished audience, it is a great honor for me to present the study that I conducted jointly with the Council of Europe on the personal data protection. I thank the Council of Europe office for the trust placed in me. We've worked together for a number of years now, and the agenda is always extremely relevant. So I thank the Council of Europe office for the fact that they address these complex issues, and the documents are in place that would enhance personal data protection in the field of healthcare. As the Council of Europe expert, I had the chance of analyzing much, and we discussed what would the structure be, together with the Council of Europe and with the Ombudsman. So we were reflecting on what would be the most effective structure. Is this issue relevant? I think it's relevant for absolutely each and every country. If we do it for the general public, we don't do it just for the people present here in this room, but when we think of all potential users of these recommendations, it could be absolutely anyone, because I think any person using these recommendations would be empowered. So, the thinking behind this report would be to create some guidelines, first and foremost for the Ombudsman, so that they could prepare their recommendations. Second of all, that healthcare authorities, beginning with the Ministry of Healthcare, could also use that, and also all the service providers and the patients. In this way, we would be able to reach the goal across the board, to provide maximum protection for personal data. The legislator has his own agenda today for personal data. in August 2024, amendments were passed. And the amendments pertaining to the right for healthcare, it says that everybody has a right to receive qualified medical services with their data protected. Is the data breached today? Well, we understand what a vulnerable sector that is. The danger of data breach and confidentiality breach is high. We realized that there are problems in this field. Our patient today is given medical documents by the healthcare service providers. That is not the case. I am the person that often writes complaints to the Ombudsman pertaining healthcare services, even though we have an adequate regulation. I think our regulations are adequate. Even the Supreme Court has already announced their conclusion, but healthcare providers keep concealing patients' data from the patients. They have both the hard copies and the soft copies, so this is an issue that is very high up on the agenda. And of course, it's a challenge for the human rights. I'm a practicing lawyer, and I know the scale of these concealment cases. So I think there are reasonable grounds for providing recommendations. So I think it would be up to the tasks, up to the medical universities to teach the future healthcare suppliers on the importance of that issues. We are in the middle of the euro integration. Digitalization is rampant, and we understand that it's a top priority these days, and therefore we need to advance our regulation and to make sure that our rights are observed on a day-to-day basis, that they're just not written on paper. You know, I can give you an example. We have a wealth of healthcare medical applications today, and nobody reads privacy policies. They just tick the box and they say, I agree. Nobody even reads that, and it's a huge problem. Take a look at the social media, another example. Look at former X, and the High Court of Ireland created an obligation to destroy the personal data that the Twitter collected. And this is a recent information, even though the Twitter alleged not to collect privacy data. And Elon Musk said that they collect data on physical and mental health. So we are extremely vulnerable these days in the digitalization era. Sometimes we consent without having an understanding of what we actually consent to and the amount of data that's available today. So it's crucial that these recommendations are in place today. We have two parts: the general recommendation for the authorities, and I'd like to stress a number of points here. And we can later discuss this in a panel discussion. Then we had the second part about the typical breaches. It's based on my practice as a lawyer. It's based on the existing experience, on existing studies, also provided by the Ombudsman office on the cases that they're looking at. So we put together the breach, the legislation, the case law of the European Court of Human Rights. Also, recommendations are provided on how to avoid these mistakes in the future. I believe that this set of recommendations will be implementable and will reduce the number of irregularities. General recommendations. I'll stress key moments, and we need to pay attention to the definitions. This is key. Talking about the privacy rights, for example, when it comes to our medical information, we have the rights of active knowing about the state of the patient's health. And I'm worried about the definition of medical information. We have two levels, the healthcare ministry definition and the cabinet of ministers definitions, and they have divergent definitions of what constitutes healthcare information. I believe having two definitions is not the case. They should be unified. Only one definition should be in place. And we know that there are certain divergencies between what's defined and what the actual documents are. Also, another important point is as follows. Sometimes the ministerial norms sometimes go against the very foundations of the regulations on healthcare. There is a very important document, an order of the Ministry of Healthcare 1435. It covers information on children who have complicated diagnosis. And this order of the Ministry of Healthcare, there's a reference to Article 39 on the basis, and the main criteria is coming of age. So we have this divergence, is that the grounds of the regulations are vague. This is the case, and it has its consequences, and there's a link to the civil code, the law on psychiatric services, and the law on the status of HIV persons. They have different qualification criteria, not 18 years of age, but 14 years. What happens if a person turns 14 and is required to give informed consent? But how can you do that if you're only able to do that legally when you're 18? Here's the divergence, and it's a complicated topic. And we write papers on that for years now. But the amendments in the regulations are pocketed, and issues thus are not addressed. And there's a position of the Grand Chamber of the Supreme Court that issued an opinion that the civil code has precedence. So no matter what our laws say, we will go to the civil code, and the civil law shall prevail in this case. Therefore, I am hopeful that recommendations would be able to rectify that. But when we're drafting the norms, it is critical that we ensure that the norms are drafted adequately. Thus, we won't have to perfect current regulations or rectify it. There are millions of people who are involved in the healthcare, and they use the legal norms that we create for them. And we need to make sure that these people who would use these people, they would be saved from the trouble of finding the solution to the difficult situation, because the regulation is vague. We hope to rectify that. And I'm excited that, at least today, through this study, we can outline the challenges. We, as scholars, see that these are the challenges, and we show it to the authorities. There is also the issue of accountability for illegal data processing. And even the lawyers who work with the data and who have these healthcare cases, you know what we need to do? We need to appeal to the Ombudsman that we are processing sensitive data. If you look at the official Ombudsman's webpage, you can see that all healthcare providers, especially private healthcare providers, have to notify the Ombudsman of a fact that they're processing data that is especially sensitive. The Ombudsman issued a decree what has to be done. And this is true for lawyers too. The lawyers who also come in contact with sensitive data, they need to notify the Ombudsman just as well. So it's a two-way street, you know. The authority needs to issue clear regulations, and the user need to follow that regulation. And we are hopeful that our recommendations would be useful for any and all, those who do the data processing in healthcare and for the people whose data is processed. Thank you for listening. Thank you for attending this presentation. I believe that, especially given the Euro integration process, and we here today did a great job together with the Ombudsman of Ukraine. And our thinking behind it was as follows. Our legislation would be aimed for Europe and approximated with that of the European, especially when it comes to data protection standards. And we have pinpointed the problematic issues. It's time for us to admit that we have problems, we have challenges, and these would be a two-pronged fork. On the one hand, that our legislation would approximate that of the Europe, and our issues would be issues. Once again, thank you to the Council of Europe office and to the Ombudsman for providing us with an opportunity to discuss this sensitive yet important topic. Thank you.
Дякуємо за ваш виступ. Тепер будемо переходити.
Thank you for your speech. Now we are going to start presenting the study findings and the recommendations of the Commissioner for Human Rights in the area of human rights respect and in the healthcare system.
Так, я попрошу, будь ласка, включити другу презентацію.
Could you please show us the second presentation?
Дякую. Отже, почнемо.
So let's start. First of all, I'd like to draw your attention to the fact that appropriate organization of owners of personal data is necessary to prevent any infringements of rights of subjects of personal data. That's something that we have to understand and remember. Personal data related to the health care is considered to be sensitive. Therefore, processing of this data constitutes special risks for the rights of the subjects of this personal data. That's why special requirements are applied. There are some obligations. It is also clear to understand that disclosing information about the health can lead to a significant violation of personal life and do a lot of harm. According to the explanations of the Ombudsman, the state of health is information that is not only about the current health, but also any prognosed health conditions. Therefore, this preservation of this data is a necessary requirement. Disclosing this data can mean a violation of personal life, of the right to have personal life, and it's something that has to be understood by everyone. What's also important is for people to have access to the medical documents. It's also important that they have access to any medical data. It's necessary for their life. Therefore, all the institutions who process personal data have to ensure protection of this data. According to the results of the checks conducted by the Ombudsman's office, upon the requests from the citizens, we can distinguish between the following infringements. Sometimes there are no documents regulating the processes related to the data processing. Sometimes there are no plans for the cases of non-sanctioned access to personal data, failure to provide information to the subjects of personal data as to their rights, as to the goal of the data processes, as to the people the data is transferred to, failure to inform the commissioner as to the data processing, also failure to inform the responsible people, and also violation of the rights of subjects to the for the access to their personal data. It should be mentioned that in order to prevent violation of human rights and in order to garner more attention to the importance of the protection of personal data in the area of healthcare, Dmytro Lubinets, the Ombudsman of Ukraine, set a clear task for the Department of Observance of Information Rights. He said that the recommendations have to be applied in the healthcare system. And another thing I wanted to highlight is that these recommendations are first of all aimed at such target audience as the processors of personal data. At the same time, these recommendations can be applied in different life circumstances when subjects of personal data file different requests or go to the court, etc. It's also important that every owner of personal data can use these recommendations in real life. We also prepared and agreed to these recommendations on personal data protection in the healthcare system. And you can find the recommendations by scanning the QR code. It's a letter with the number, so you can find just a simple list as well as the formal document. You can find them also on the official website. These recommendations touched upon the grounds for the processing of personal data, the communication to the subject of personal data. It's also about the right of patients to access their personal medical data. It's also about ensuring the right of family members to get information on the reason of death. It's about the process and the procedure for personal data processing. As to the first point, grounds for personal data processing, I'd like to mention that some cases are clearly defined by the law, and getting access for personal data protection might be unnecessary in some cases. The consent of subjects of personal data can constitute only one of a number of grounds for personal data processing. According to some provisions of Ukrainian legislation, in particular the law on personal data protection, some data processing can be done without consent. For example, if it is done with the aim to establish diagnosis, to provide medical services, to monitor the compliance with certain norms, also when it's within the electronic medical system, provided that the data is provided by the medical personnel of medical institutions. There are quite a few cases like that in our legislation, and we give the references to them. So in every case, personal data owners have to be conscious of the goals of their data processing. In some cases, their consent might not be necessary. As to informing the subjects of personal data, we need to understand that even if there is no consent, we have to inform personal data owners about the fact that the data will be processed. We have to inform these people, and there may be two types of communication, and there are also terms and delays specified in the recommendations. So the informing of subjects of personal data have to be ensured according to the legislation. In case of processing of data which constitutes specific risks related to the healthcare system, the Ombudsman has to be informed of such processing and of the responsible persons defined by the respective orders. And therefore, this information has to be provided to the Commissioner for Human Rights on the fact of the processing and on the responsible people. If you are accessing this data online, you can click on the links and download all the information. We also should mention the right of patients to have access to personal data, their own medical personal data. The access to their information is an important element of democratic society. It is also related to the processing of their personal data. People have to be able to control what's being done to their personal data and rectify any data. Our legislation provides for this right for access. It is mentioned in the Constitution, in the law for personal data protection, etc. So the right to access is an important component, and enjoyment of this right can be done by filing a request. And people should also know what data is being verified, because the data which does not correspond to the reality will obviously have negative consequences for the private life of people and other areas. So people have to be able to rectify this data. Owners of personal data have to ensure access for patients to their personal data. We should also mention the right of family members to learn about the reasons of death of the patients. It's a sensitive topic, but it's important for people, for our citizens, especially now when we are going through this difficult period. The family, the close ones of the deceased patients have to be able to learn about the reasons of death and get familiarized with the medical opinion. The law also says that the state guarantees confidentiality of this data, and it has to be preserved according to the law on information protection, and the citizens can file requests to get this information according to the law. Also, a procedure has to be followed to when sensitive personal data is processed. All the processes have to be regulated. The general requirements to the personal data processing are provided for in the typical procedure approved by the Commissioner. You can also find the link to this document in our recommendations. According to this procedure, and the processors of personal data have to define the way of processing and collection, the condition of preservation of this data to ensure the confidentiality. They have to define the clear process they follow. It's also important to provide training to the personnel who conducts personal data processes. So the plan of actions has to be created for the cases of incidents and extreme situations. Finally, the recommendations also mention the duties of owners and processors of personal data, and they cannot disclose this personal data. The document also mentions the liability for disclosure of this data, as well as disclosure of medical secret. So owners and processors of personal data have to use the necessary procedure and to follow their obligation of non-disclosure. Finally, for the Secretariat of the Commissioner, it's very important to prevent any human rights violation and therefore to ensure the privacy. So I'm happy we all gathered here to discuss this important matter. And if your rights are violated, or if you learn about any rights violations, if you need any recommendations as to the application of our legislation, you can reach out to the Commissioner of for Human Rights. Thank you. And now I would like to give the floor to Irina Senyuta to open the panel discussion. Thank you, Alexander, for presenting the recommendations. It's very good that we have these recommendations now, and I think it will be very useful to apply these recommendations together with the study findings. You mentioned the documents that have to be followed, and within the study we had a request to create the annexes, and you can find 4 annexes, so you can find the list of documents that the medical institutions have to use. So thank you very much for presenting the recommendations, and thank you for the partnership. Let's open the panel discussion to talk with our experts to discuss the important issues and to get the opinions from the academic community, from the practitioners, and to get clear recipes. I read that personal data is the currency of the 21st, or the oil of the 21st century. On the one hand, it scares. On the other hand, it makes us reflect on this statement. So today we are going to think about the essence of personal data. No one has the right to get one's personal data without their consent, and we are approaching the World Day for the Protection of Data of Patients, which will be celebrated on the 17th of September. It will be the day of the privacy of patients. And in the context of personal data protection, it's important to mention this day. So together with the experts, I'd like to discuss everything that can be done today in order to ensure safety of patients' data. We are going to have complex questions today, complex discussions. They might not be comfortable and easy, but that's what I want. So I am pleased to introduce the speakers. If you have any questions to panel discussion participants, please raise your hands. We will be able to ask the experts. I hope everyone will be able to do that.
The thing I'd like to discuss today is, first and foremost, they pertain to what I began with. Can personal data be a commodity? Fruit or vegetables that can be bought? So when I want my lawyer to enable us to legally buy a personal database from one healthcare provider, I mean, imagine I am a new healthcare provider and I don't have a database of clients yet. Because it's a new facility. No patients have used my services so far. Am I allowed to purchase such a database? For once I came to a healthcare facility and because they invited me, but I've never been to this healthcare provider before. So I was wondering, why did this provider have my data? Because I've never used their services before, and I asked them and they just disappeared. So I'll give many examples from my professional experience, and it's something I'd like to discuss with the experts today. So why I ask, can these data be a commodity or goods? Because they are up for sale. Much to my chagrin, this is the case. The data is sold these days. So that's why I want to discuss that. So my first question will be addressed to Olena Kochanowska, LLM. She's the professor of the National Academy of the Legal Sciences. And she's also a member of the Kyiv National Taras Shevchenko University. Olena, a difficult trick question to you. Can personal data be a commodity? How can you protect them from becoming a black market commodity? I also have a second question for you. I stressed the contradictions between the civil code and other regulative acts and legal acts, and the regulation needs to advance, not to contradict internally. So do you think advancing regulation can help the healthcare and bring more clarity and remove the conflicts that we see today? Thank you. Irina, thank you. This is a very difficult question indeed, and it has different dimensions of complexity. First, what is the most important for a legal definition? What law and what relationship is regulated. So it's the civil law that looks into this relationship. So for personal data, we would need to look at a number of so-called objects. For example, the civil law sees such objects: information. Information is stipulated as a separate object in the civil code of Ukraine. We have personal, non-material goods of natural persons. And during the review, we will add also the legal persons, because some of this information might be owned by the legal person or a company. Now, second, there are objects that constitute this system. The civil code doesn't have such entry as the personal data as an object of the law. But in this concept of civil code amendment, by the way, you can read it. It's publicly available on the internet. There are also printed copies of that concept. And you can see that the civil lawyers today aim to include the personal data into the list of the legal regulation object by the civil law. So what would be the benefits? Well, first and foremost, the objects that are listed in the personal data are separately goods, non-material goods. And this is why they are unalienable from the natural person. It is the essence of an individual, so to say. There are more sensitive or less sensitives, but taken together, we can see that there are personal, non-material goods. Unfortunately, it's not stressed enough today, especially by the legal drafters of the personal data, and also for those who are working with data protection. One thing tends to be missed. The civil code is the code that needs to be consulted when looking at this issue, and people don't. Now, information is stipulated in Book 2 as a non-material good. So, the possibility of what we call the convertibility of the civil rights, we can make an analogy with the intellectual property objects. For that field, yes, practically any of the object can be goods or commodities, not just the material goods. Sometimes the intellectual property is viewed as a commodity, as something that can be sold. However, for non-material goods that are not economic by their essence, they are non-materials, you cannot simply handle them, as in ordinary lives. It's not something that can be ordinarily bought or sold. So, when Irina says that there are groups of these rights, right, taken together, but we cannot use comprehensive approach here. These are not shared rights. These are individual rights, and that's why they're safeguarded and protected by the civil law, inter alia. And they are protected in this way because they're individual. They belong to every individual. So the approach, I bought this and I can do whatever I want with this, is irrelevant. even if you bought it in one way or another, not to mention the possibility of challenging this purchase. But imagine that you buy these database, you would still have to get every person's consent on that database.
Документи, про які ми сьогодні говоримо, да?
But you, dear audience, have you ever received a document that we've discussed here today? Personally, I have rarely been approached so that I give my consent so that somebody else uses my data. Moreover, the technical equipment is so advanced today, and I don't see it in the healthcare so much, but in the commerce, definitely. You enter a website and you will not see the content of that site before you give the consent. You're simply standing at the threshold, metaphorically speaking. And if I do not want my personal data used, it's better for me not to go on that website, on this e-web store. When it comes to healthcare, there's even greater sensitivity there. So, Book 2 of the Civil Code regulates also the right to life, the right to healthcare, the right to non-disclosure and confidentiality. But there are subtleties there. The civil law is at a higher level of protection. For example, if a family member comes to visit the patient in the hospital and on the ward, you have 2 or 3 patients, and the visitor accidentally hears information pertaining to other patient, then this visitor would have the same liability for handling the information as the doctor or the nurse. So our civil code is treating this subject very broadly. So the civil lawyers, scholars' approach to that is very comprehensive. Our concept has the following lines. We would like to ensure the protection of personal data and strengthen the right to privacy, because the European tradition also includes the right to privacy. So, of course, we take that into account. We suggest that we ensure the civil law protection of the personal data right. We shall define the right and its place in the system of personal, non-material rights. So we want to define the place of that right, and we have a few of them, including the right to information, the right to honor integrity and business reputation, the right to personal papers, and the list could go on and on. So we are suggesting that we also need to amend the law of Ukraine on personal data protection. We want to make sure that the laws are logical. Obviously, the code would preside over other legislation, and I am baffled sometimes when laws are being drafted, but the code that is in force is not consulted at all. However, even though it sets the overarching principles. So if people fail to use Article 3, if people fail to understand that there's this European approach for regulating, protection and safeguarding rights, if people fail to grasp the principles of the civil law, and one of the key cornerstone principles is the immunity of privacy of an individual. So we say that the general data protection regulation provisions need to be taken into account, and we need to differentiate between the right to access for personal data provided free of charge electronically, also a thing we noticed, a thorny issue, and also the right to mobility of personal data, the right to require the transfer of personal data to a different owner. I mean, you can even hear this is the civil law terminology. We don't talk about the right of ownership vis-a-vis these objects. It's about owning. So there's an owner in terms of physical object, but information is not that kind of physical object. And we need to understand that handling it is much more complicated, even if we codify everything. We will not prevent the possibility of not spreading the information. I suggest that you try finding information on any individual you're interested in. You're most likely to find, and actually, if there's an absence of information train of a person, that might alert you. Well, if you're talking about older generation in their 60s or 50s, that can be explained. But I'm sure that for anybody who is under 50, there's an information trail on them. So my point is that apart from drafting legislation, apart from being experts, we also need to do outreach, because the key way of protection here is self-protection. People should not disclose information about themselves. They shouldn't do that single-handedly, and this is the best. Keep silent, and silence will save you. There's an old Oriental adage that goes like that. People would provide their data willingly every so often without even heeding these warnings, especially when it comes to their health, especially when there's urgency in addressing an issue. People do so willingly. So if the provider says, oh, we don't have the documents, we won't give you any papers, and the individual understands that they need to act promptly. So the process of self-data protection is something that is helpful to us in civil law. This is how we can address our problems here. So I'd like to call upon everybody. If you work in this field, please consult the civil code. We have principles and we have ways of protection, and there's also the moral damages, and we have absolutely every tool. Even if we didn't have a separate concept of personal data, we could use Book 2 to protect the rights of individuals. Olena, thank you. That was exactly my point I expressed when I was talking about the general recommendations for the National Health Service and the ministry, and it's critical when the ministry drafts the norms, it's critical that they remember that we have regulations and the civil code, because there are ample examples when that's not done. Okay, moving right along, we're in the middle of the martial law, and we face certain restrictions coming inter alia from the constitutions. Are these restrictions legal is a matter of a philosophical debate. So when the president instituted the martial law, you can see that there was a possibility of restricting Article 49, but president decided not to do that. There's another decree, and as of the day before yesterday, it was in form. It was the decree of the Ministry of Health number 374, restricting the amount of medical services provided. There are many, many examples of where the ministry drafts the norms. The Constitution allows for these restrictions, and the Constitutional Court has numerously spoken about it. Still, sometimes we see these ministerial norms, the norms created by the ministry. Today, I'd like to bring up a crucial issue of the guarantees. It is critical that these guarantees are effective, and we will talk with Ms. Onishenko, a professor, academician of the National Academy of the Legal Sciences. She is a member of the Koretsky Institute. She looks into these issues. So, Natalia, 2 questions to you. First, what would you recommend in the martial law to observe the personal data rights to the greatest extent possible? And my second question is, what are the important safety guarantee to protect? What does the government have to do? What do people have to do? The previous speaker brought up self-protection, so that people just simply don't just simply click consent, consent, consent. For example, I come to the healthcare provider and they give me the consent form. And I say, okay, I can sign it, but there's no legal requirement for that. And the service provider says, oh, but the ministry wants it. I say, okay, they might want it, but this goes against current regulation. So, Natalia, over to you. Sadly inaudible. The speaker doesn't seem to use microphone. So, let's start with getting to the bottom of the specific issue. Thank you. So, what is the essence of the discussion here? Personal data, protecting them. The question number 1 is here. What is the correspondence? So, in the case we talk about individuals and the patients, do you see, are there any specific guarantees pertaining to the patient? And if it's the case, then what are those? As I was preparing for this discussion, I reviewed many materials. I found something new there, and I came across such term as the patient's autonomy. This doesn't come from our legislation. Self-governance of the patients definitely was translated from English. I don't know, maybe my translation of that term is not perfect, but my question is what that is. So, I think that there's a problem of freedom and the problem of justice. To what extent can we give up freedom for justice? Therefore, protecting things or not protecting things? Once again, this is a philosophical debate, and I suggest we discuss something else. So the legal certainty that we have today, do we have any pertaining to these subjects? So legal certainty is a must. What exactly are we protecting? What personal data? Is this an infinite subject, or there are certain limits when it comes to individual and to the patient?
Second question is very important, which is formal certainty as to what legal acts we are going to use, starting from the articles of the Constitution and moving through other legal acts. I listened to your speeches, and I understand that, unfortunately, the legislation is something we would have to rely upon. We don't always remember that we have to refer to it, not even rely on. I'm trying to search for the correct word. It's just something which is missed. So legal certainty, formal certainty. To work on something, we need to rely on something. Then the circle of subjects, who we are defending, to what extent, and who is defending. It's also an important point that has to be subject for discussion. Do we have enough means to protect rights? Of course, we have the institution of the Ombudsman of Ukraine, we have legal remedies, and the question arises, do we have sufficient access to legal remedies? And it's very interesting to listen to the colleagues who might be able to tell us more about the legal cases and whether the access is easy enough when it comes to the patient's rights protection. Not a lawyer, it was not a lawyer, not a medical specialist, but someone said that if the rights can be deprived of, these are not the rights. These might be the privileges. So if rights can be violated, are these rights or are they privileges? And speaking about the guarantees, Ms. Arena asked me about the guarantees. They can be general, like specific ways to protect yourself from discrimination. They can be national and international in political, economic, and medical areas. They can depend on specific enterprises or organizations. They can depend on the media, on special bodies, international commissions or ombudspersons. But still, why do we have a number of guarantees and we keep discussing violations? If we speak about the autonomy or self-governance of patients, why don't we discuss the cases when patients do not want to defend their rights? We always offer to protect someone's rights, and we never consider cases when people refuse that their rights are protected just because they have their autonomy. How is this case correlated with the notion of justice? It's not so easy, right? So the protection should not be something we keep imposing, we keep thinking about in different circumstances. We should always base our activities on the principle of autonomy of people. And we have to be interesting for the patients. It's not only about signing any document. Another very important question is about legitimate expectations. What do we expect? What do ordinary people expect? And what patients expect? So we should think about the correlation of these expectations. Why sometimes these phenomena do not coincide in our civil life. That's also a problem. I can also speak about the topic of control. It's a tool of a democratic society. Control is something a democratic society is interested in. And Irina knows that I adore this topic because on 17th of September, we're going to celebrate the Day of Patients' Rights, and on the 21st of September is going to be the Day of Peace. And I think the best guarantee of protection of legal interests of human rights is just peace. And then we might speak about different complex issues that emerge in respective areas. Thank you, Natalia. You asked about court cases. the Unified Register contains cases when people file requests to get copies of the medical documents. And it's positive that the Supreme Court mentioned the violation of right for privacy. I think it's a good sign, and it's important to speak about the violation of the right to privacy. As a lawyer, I've never filed any requests with the court on this topic. We could see the reaction of the Ombudsman, and we could see copies of medical documents provided in some cases. So for many times I've used this tool. There are different ways, and when you mentioned another topic, I remember that some patients should understand that it's about their life, it's about violation of their rights. They might take some decisions, and I will be the tool. I can devise the strategy and the tactics, but I cannot take a decision instead of you. You can choose from the whole range of legal tools to protect your rights. So let's continue, dear colleagues. The following questions are not going to be easy, and I would like to say that mobile apps are quite numerous today. They might be free or not. Sometimes we should pay with our personal data. And, you know, I was impressed with one of the latest consultations I've had. A couple lost their child, and they came me to the with medical documentation, and they said that lung hypertension was said to be innate, and we have a different conclusions saying the contrary. We opened the ChatGPT, we uploaded all the data, and the ChatGPT gave us the answer, and it said that it was COVID, which was diagnosed too late, which led to lung hypertension. And the client said, you know, now I write to the ChatGPT with problems I have. The ChatGPT prescribes some tests. Then I provide the test results to the ChatGPT, and the ChatGPT prescribes medication and the treatment. Then I consult with the doctor, and doctors might confirm it. I've been in the system of healthcare for 22 years, and it was the case when I couldn't understand what's wrong, what doesn't work in our system, or are the tools as ChatGPT able to replace people. So we often don't think about it, but we always look for someone who will treat us and who will be correct in the treatment prescribed. So we need to think about the nature of the relations. When people lost trust to other people, they are looking for mobile applications, for such tools as ChatGPT. They want these tools to work, to be legal, and patients want to be able to check whether doctors are right. So in the era when we talk about digitalization, about a huge number of medical applications, we also have a lot of medical systems. And no offense, but I will speak about the one which is the most spread today. Everyone who's signing the declaration with the doctor, they understand that their data is transferred to the healthy. system, I used open data, and I learned that a healthy system is not a state-owned system. It is a private system bought by Kyivstar. And I have a question to the representative of the National Health Service, Marina Onovchenko, from the Department of Health, Electronic Health System. And I will have two questions. Since the National Health Service has to control, in particular, technical requirements, the topic of standards, I would like to ask you the following. In your opinion, Marina, is it safe that the medical information system is in private hands and our personal data is in private hands? That's the first question. And what are the tools and what tools the state might use so that our data is not processed illegally? As a consumer who got to the healthy system, I could review the text messages I got from Healthy, and it was in particular that the Healthy can decipher the test results. I didn't consent to the data protection in response to this message. I usually just read similar text messages. I saw that according to the current register, they are not licensed to conduct medical practice. So I have the following question to you. How should the National Health Service act when the information does not correspond to the reality, and how do you control the observance of technical requirements? We have a set of technical requirements to any medical system. How do you control their observance? Thank you very much. Thank you for the invitation, for the question. First of all, I'd like to say that the National Health Service is the owner of the electronic healthcare system. And the National Healthcare Service is responsible for the central database and for the information contained there. There is also another component of electronic healthcare system, and its owners are other people. So the National Healthcare Service is responsible for the information which is transferred from medical institutions to the central database. That's the first thing I wanted to emphasize. If we take into account the law of Ukraine on personal data protection, we have the National Healthcare Service and the medical institutions. The medical institutions will be the owners of medical data, and we will also have another agency which will be the processor of personal data. The processing will be conducted in conformity with the data provided by the medical institutions on the grounds set in the law. And the consent can be collected from the patients to process information, and in this case, the National Healthcare Service is not responsible for this processing. because it's the consent provided to other agencies. So if you get messages asking to provide your consent, it's not something the National Healthcare Service is responsible for. We are only responsible for the information transferred from medical institutions to the central database that we own. And these other agencies can be institutions that provide other services and not medical ones. As to the control, how is it ensured? First of all, there is a state agency of which is an administrator of the electronic system, and any electronic medical information system has to be tested, have to be verified according to the order number 411. Every electronic medical information system has to be certified. If the commission which consists of representatives of the National Service, of the medical agencies, if these members have any questions, any doubts, we do not connect this electronic system. We might also disconnect this system after some verifications. So we disconnect them from the healthcare system. So it is something which is controlled and regulated. This system might not be able to cooperate with medical institutions and conduct any activities related to personal data. Any electronic medical information system and other institutions know that we always have to comply with the legislation on personal data protection and all the other legal acts. If the question is what are the means to control, we conduct regular monitoring of the activities as well as verification. So everything which is required from the National Service according to the legislation is being done, but we do not have such a function as verification of the processing of data. That's something which the Commissioner for Human Rights has to control. And we would like to get clarifications and recommendations from you. How can the consent be controlled and monitored if it's something which is done on their own initiative, on the initiative of specific agencies?
We want to work closely together with the Ombudsman and receive clear instructions and recommendations from the office, because healthcare data today is rampant and protecting them is key today, because medical records are something that we handle and it's very thought after. So hopefully I've answered your question, unless I missed something. So Marina, one more point from my side. I have this aftertaste of not understanding This is not clear to me, neither as a scholar or as a practitioner. Why the personal data is given away to private entities? This is something I don't understand. And my feeling is that we are not protected as citizens. I am not clear why the government decided to create it this way. Basically, these databases are sold and subsequently sold. Can you understand that the database can be sold to a private entity? For me, this is not adequate in a state that is aspiring to become a legal state, or where the rule of law is instated. Second, the individuals do not want their data unpredictably taken away from a system, whether it be a central database or a local database. Elon Musk's company was forced to destroy the database because he wanted to avoid a huge fine, and there are no obligation for companies to do that in Ukraine. I will give you a case. There was a client who lived in one region and then had to move for another region, and then she moved abroad, and it was in the times of war. And then she finds out that she was tested positively for AIDS, but at the time when this test allegedly was made, she was abroad, and she says it's not true. All the doctors absolved from responsibility. They said, we don't know why she wasn't notified, and none of them are held accountable. I think that private structures are not controlled and not kept in check. They said, oh, the private healthcare provider say that, oh, we cannot do that. And I said that there's a decree of the Ministry of Healthcare have a right to do that. I just want to make sure that all service providers, private and public, don't have the same obligations. Irina, the law on the protection of the personal data is very clear. The government is the handler of the data, and there is no clear cut who can be the handler of the data. So these service providers are allowed to handle the data. Now, the question is, who provides the inspections? It's the Ombudsman. Why doesn't the Ombudsman respond? Yes, we have loads of appeals from individuals that Kyivstars or Healthy Me, we get loads of appeals and we provide our justification. But the National Health Service, as the executive body in the field of basically, well, it provides the funding to the healthcare providers. We don't have that mandate because every authority should comply with the regulation, but there are other entities that need to respond and provide recommendations, clarifications, and to act on it. It's also true for the healthcare institutions. You need to cooperate with the institutions, with the medical doctors. You need to explain to them. You need to stress that they need to be held accountable if needed. Indeed, things happen where doctors enter false information or inaccurate information. This is common understanding. But there are institutions that have the relevant mandate to counteract, and the National Health Service complies with its obligations. In terms of correcting incorrect data, the law is explicit. It's only the right of an individual. It's Article 15. And a process is set out there clearly. there are certain provisions of Article 15, but the process for implementing them is absent. How an individual needs to prove that data has been entered inaccurately. We need a certificate. If there's a claim, then the person needs to go to court and need to prove that we are erroneously processing the data. For example, if there's a wrong date of birth in the system, for example, then we'll correct that. However, there is no clear legal mechanisms. On a daily basis, we're receiving appeals or complaints from the citizens that want to remove their declaration and terminate all the relationship with the healthcare providers, and they want all their information be deleted. But it is impossible to delete all information from e-healthcare system because the entire patient file is lost because there is no paper-based. But then again, a comprehensive mechanism is required as a legal act. And the National Health Service of Ukraine complies with the legislation, and when it comes to healthy services like Healthy, you need to ask Healthy what were the grounds for them. Marina, you know? Yes, we'll come to you later. So it's my opinion. This discussion shows that we are looking for a range of methods, legal and that of monitoring. We're amending a lot of norms presently, so we need to address the issue. You see, an individual has a right. I have a legitimate expectation. I believe that my data will be protected, but this is not the case, unfortunately. Now, moving right along. I do not have a choice right now. I'll explain you. Because if you select a medical doctor and you sign the declaration of choosing a certain medical doctor, and it's just the healthy, it's the pervasive system for the primary healthcare. And I want my data to remove that data from Healthy for a reason, and that's impossible. So if the doctor is in the system of X, Y, etc., and they can have access to my data, even they're in a different region. And I tested that personally. Question, the general practitioner answer, not just the GPs, unfortunately. Now, the legitimate expectation that we brought up today, this is the Constitutional Court, this issue doesn't apply to personal data. And e-health is on the agenda in terms of Euro integration, legal acts, harmonization. All of these points are key. It's a sensitive debate, but it needs to happen because we cannot keep turning a deaf ear to the people. I talked to the healthcare providers today, and I hear, one provider disclosed the confidentiality of one of the employees, and it was sensitive data. But you see, every member of the healthcare provider has access regardless all the employees. But the European Court has ruled on that in a case against Finland. But we don't read those European case law. So even internal access within the system is monitored. And if I'm a doctor, I can check if a certain individual is pregnant or not. But this is nonsense. This should stop. So when you actually come to think of it, it's threatening. Irina, the doctors need to be aware that they have certain responsibility as well. Greater outreach to the doctors is needed. Who should do it? Answer, those who have the mandate. It's the Ombudsman has the mandate to control and monitor the personal data protection. We provide things. We have loads of different projects together with the civil society. We host workshops, etc. But as the head of the personal data protection unit, I do not have the mandate to do that outreach. But then again, you need to see if it's punishable or not, or if it's in the legislation, if it's in the regulation. So you need to amend things for people to be afraid, so that people have afraid accessing someone's file and checking information there. Marina, I took note of the point 7 in the general recommendations, and we discussed it with Alexandra. Who could do that? So each healthcare provider needs to have at least one officer on personal data protection, or entire units. Who teaches them? It's just another item on the responsibility list. People are not taught to do that. They're not trained on that. And therefore, they don't do their job very well. But today, there's an obligation. Everybody who's in charge of the military information filing processing, they need to be trained in that. Similar things can be done for data protection officers if this training is made compulsory, or if we just do some personal development on personal data. The Ministry of Healthcare provided maximum 8 points on CPD training, so we need to address that. Personal data needs to become obligatory and needs to be allocated a certain amount of points. Okay, military records are important, but so is personal data. So I think number 7 from recommendations need to be implemented. And then we would have the person who's accountable for that, not just the Ombudsman in general. You need to have an officer who's responsible for that, who could bear the responsibility if something is off. And it should be a specific individual in every healthcare provider. Personal data is one of the most convoluted topics. It's hard to get your head around that. And there are very few people who have a perfect understanding of that topic. So it's up to the higher medical schools, to the authorities who draft the regulation, to work together. Marina, thank you so much for your remarks. Alexander, over to you. Thank you, Irina. I wanted to answer the question. Healthcare is always an emotional topic. That is understandable. It's always been that way. But then again, please be aware that current Ukrainian regulation sets out that the medical information system work in a certain way, because the regulation allows them to work in this way and to process data in this way, because it was in the legislation. You cannot just label them as private companies and therefore it's illegal, etc., etc. Yes, they are private companies, but they need to comply with the personal data protection regulation. We're also receiving appeals and we conduct inspections. To process personal data, granted, you need relevant regulation. This is also true for the medical information systems, or the MISs. Now, on the point of medical doctors, Every so often we receive these appeals that the medical doctors entering the data in the e-system through any MIS, and the doctors sometimes make an error.
Тому також було б добре досить таки, щоб
Therefore, it wouldn't hurt that jointly with the Ministry of Health, or maybe the Ministry of Health, communicated clearly to the doctor, please verify the tax code before you enter into the database. Even I personally, when I come and I say my surname, how would a person identify me? Maybe it's not me, maybe it's not me. So what are the claims that we guess that a person has been entered on a medical visit when they didn't visit? I'll add to your point, Alexander. The National Health Service needs to verify and whether the person has been identified clearly, including the date of birth, etc. But if you are signing a declaration, also when you sign, please make sure you check your personal information, whether it's entered correctly. The National Health Service also verifies that information, but we also encourage that the patient do it. Alexander, the aim of this discussion is not to blame anyone. It's something else. We are about to experience change because of the Europe integration. And we have already crossed a certain stage of e-health. You're right. The regulation is there. We're not saying that having a regulation is bad. But what I want is that my expectations are legitimate, because the National Health Service says I'm responsible for e-database and central base. And who's responsible for private databases? How many of there are? And everybody points to the Ombudsman, but I understand that the Ombudsman's office is incapable of checking absolutely everything. So we need to look for gaps and all the problems, and we need to be sincere here, and we need to sit down and think. Would it be appropriate for the future for those databases be in the private hands when the legislation is amended? And I think it's a subject for a debate, and we need to start today, because Euro integration is happening already. Therefore, the debate needs to happen now. And I see certain issues with that. Right. And moving right along, we've discussed certain problems, and we highlighted that so that it would help to the service providers and the patients, but also to the government institutions so that they see where there are problems. The Ministry of Health has always have their hands full. They cannot notice each and every pain, as I called it, a pain point. The patients are nervous. They might be emotional because their data fall in the wrong hands, but they feel helpless to do something about it. As patients, I am a lawyer, and I was shocked at certain cases. So we need to act, and we need to act now.
You have to understand that there are things that will never replace people. The ChatGPT will never do a surgery. And I keep repeating that protocols, it's a system of coordinates, and we need to follow it. Otherwise, the person, the medical universities and higher institutions will be useless. So we need to address this topic today, and our today's discussion is specifically to discuss the problems we have. And actually, we will give you the opportunity to ask questions. If we have enough time, we will take these questions. Another problem I see in this area is something we already mentioned. I would like to talk with Vasil, who is a judge. We've talked about collisions, about expectations, and the question is, on the one hand, our legislation, our practice of the judges regulate these topics. However, there are a lot of requests to the Ombudsman office, a lot of demand for legal services. Why do you think people are not provided medical documentation? Why do you think they have to reach out to the Ombudsman? Why does this problem persist? And the second question, there is the problem of different interpretation, and I can see a collision between the law on personal data protection and other legislation, and I do not understand whether I need the consent for the personal data protection or not. If you, the court, get complaints of this kind, how do you adjudicate in these cases? Because our legislation says that we have to sign consents for personal data protection, but actually it's not a completely correct understanding of our legal provisions. And Article 24/2 says that we have to consent to get access to the healthcare system. And what about the cases when patients die, there is no one to provide consent? The civil code allows family members to get this access to the relevant data. So is our right violated in this system? What should we do in case of such a conflict of norms? Hello, dear colleagues, dear friends. I'm happy to see all of you. I will not tell you the answer as to the actions of the Supreme Court. It's something which will lead us nowhere. Let's speak about the civil code. We were mentioning owners, handlers of personal data. In the analytical study, the civil code is mentioned, and I don't see it in the other document. If it's there, please show me. And Ms. Irina asked questions related to what's there in the civil code and what's not present in other legal norms. I will explain why it's mentioned in the end. Right. What is from the civil code? So what was the reasoning of the cassation court in civil cases? There is Article 4 of the civil code, which ensures some kind of stability in the area of private relations. The private life is the area of private relations. Article 4 should be something which guides us in courts, in the government, and in other bodies that use provisions of civil code. What algorithm was suggested? And first, it was mentioned only in a few documents. Then we saw several resolutions of the Supreme Court of Ukraine saying that Article 4 is fundamental and civil code is the main regulator of private relations, and in the subsequent practice of the court, we could see how the provisions of the civil code and the resolutions of the cabinet of ministers were interpreted and used. So we will be able to look at how they were referring to the Article 4. At some point, they set a rule that the information cannot be uploaded anywhere if it's outside of the legal provisions. We heard today the Article 285 of Civil Code 286. So the main regulator of private relations is Civil Code. It contains answers, if not answers, then hints to a lot of questions. Recently, the Supreme Court was considering a case on deleting an internet article. There are no provisions like that. Someone might say that there are two different judgments of the European Court of Human Rights and European Court of Justice. But the court said that the provision we have is not clear. We recently discussed the topic of artificial intelligence and copyright. We currently live at the time of technologies, and if we compare what we had a few decades ago and now, we should realize we did a huge step forward, and it's something which is inseparable from our life, and we want to use all of these means, having legal certainty, predictability, etc. So the question was about the conflict of norms. How can we address them? Of course, we have to understand how the bylaws, the provisions of laws are correlated, and of course, the civil law has to have a priority. I hope we will keep discussing, and we will agree that private relations have to be legally regulated, and it has to be done according to well-defined norms. We often suggest different norms, different laws, and at the subconscious level, we understand that it is now well regulated. If we look at the practice of institutions of the first and the second instance, we will see that they choose the norms that, in their opinion, regulate the life. And we got carried away. At some point, we will have to say, stop. Why did we have the collision between the 24/2 and the law on personal data? Because we got carried away, everyone was dealing with their own issues, and if we try, we will find some irregularities and discrepancies with the civil code. The European Court of Human Rights keeps writing that the law has to be clear, understandable, and predictable. Let's answer the questions. Are our norms clear and predictable as to their consequences? Probably most of us will say no, they are not clear at all and not predictable at all. So, as we keep regulating and creating new provisions, we have to think about a rather conceptual application of these things. Of course, not everything will be used in the Court of Cassation in other instances. The question is, for example, can the information be deleted from the database? I keep getting the messages, and if I had time to start arguing with them, I would start explaining that if an internet article can be deleted, personal data can be deleted. So we need to have this clear tool. It's my right. If I don't want my information to be there, I need to have a right to ask for its deletion. They do not provide information. So then in this case, we should lose the tools we have. In the healthcare system, the cassation court has a certain reasoning. They say that patients have to describe in general terms what the problem is, and then the burden of proof should be on the medical institutions. There was a similar case in German system. At the level of federal court, they managed to put the burden of proof on the institutions. The people who file requests with the court have to say that they were not provided adequate medical services. Of course, we can come up with a separate process, but from my point of view, it's something which will take a lot of time and won't be effective. What's easier is to put this burden on the institutions, and they will have to provide the documents themselves. Of course, it has been a long path, and I can see that we've had some positive improvements. They are not sufficient. I prefer some tools from other countries who made available some schemes and algorithms to calculate the sums of reimbursement. So in this context, they acted this way. We don't have these clear algorithms. We have only approximate criteria that allow us to calculate approximate sum of compensation. In other cases, we don't have well-defined criteria. Of course, it's an additional means. However, people are not required to go somewhere personally and demand to be provided with medical documentation. The civil code has been there for 20 years, but we need to keep improving it, to keep teaching it, if we may say like that. And we need to think about how these rights can be protected. This question arises from time to time, and we have to take the necessary measures. At some point, we might have to say, let's stop and clarify what we have and what can be applied. Thank you. Since we rarely get this opportunity to talk to representatives, to such representatives as you, we always want to get the answer to the following question. For example, if the Ministry of Health develop a law, they forget to think about how it can be aligned with all the other legislation we have. For example, we have the resolution of the Cabinet of Ministers as to the conditions of license provision, and we lack a systematic approach. That's why we get so many conflicts of norms. When a legal act is not organically aligned with all the rest of the legislation, it causes problems, and we have an obligation to align it. Sometimes these things are missed. And finally, I never resorted to such a way of resolution of cases as court decisions, because sometimes their provisions are effective, sometimes they are not. And I really lack some verifications or checks as to the personal data processing. If you're not provided with the documents in the very basic level, we might need other means and other tools. We cannot wait for being controlled and being taken care of. We have to take care of our personal data ourselves. And let's wrap up our discussion. We have the Deputy Head of the Analytical Department of the Supreme Court apparatus, and we would like to discuss some problematic questions in the activities of the courts.
So, let's focus on the criminal cases. So, what I'd like to have a look at is as follows. Access to documents with protected patient confidentiality is regulated in various ways. Even the Supreme Court is not consistent. Temporary access through court ruling or the investigator's petition is enough. And today I said that the ground is in line with the prosecutor's degree. As a lawyer, as a defense lawyer, and it's an adversarial process, and the key task is to prove the inadmissibility of the evidence. So my question to you, Hennady, is as follows. So what do you think? What is your take? Do we need or do we not need the judicial control for accessing patient confidentiality data documents? And another question is as follows. I had this case that a man died and the mother complained that the data of her son was disclosed to the barrister of the opponent at court. Obviously, the pretrial investigation started Article 182 of the Criminal Code, and this is criminally punishable act. And according to the law that after death, the information needs to be stored privately. However, the law enforcement system is so sluggish that they didn't investigate the case and they closed the case. But once again, this is the aftertaste of lack of protection. So I tried to reopen this criminal investigation, criminal proceeding, and the person was no longer eager to fight for her rights because this effort has not been proved effective. It's a question addressed to the Ombudsman. How do we make the legal means protection? So the Ombudsman relegated the case and there's no other mechanism to follow up. So do we need a new law on the Ombudsman or amend the current law, or do you need a bigger mandate? So the question to Hennady, any case laws on Article 182, any recipes, what do we need to do to rectify it? So it's the intersection of maintaining privacy and confidentiality even after the person's death. Irina, thank you for inviting me and for having me and contributing to this meaningful discussion. As you brought up the healthy system, I have a healthy app and it says authorize yourself, identify yourself if you want to access your medical file. And I decided not to, based on what I heard here today. You know, it's quite a perspective-changing experience once you really come to think of it. So we had a really important discussion today. So I'll address the second question that you asked, Irina, on Article 182 of the Criminal Code. Well, this article isn't used much in Ukraine. I had a look at the statistics by the State Judicial Administration from 2018 to 2024. So the number of indictments, 3 in 2018, 1 in 2020, 2021, 12 individuals were sentenced, and 4 people in 2023. So these are the sentences that have come into force after all appeals and possibly cassation cases. The role of the Supreme Court of providing legal opinions is as follows. I found just one case where the person was held accountable under this article. Also, Article 31 was in this case. And the individual was acquitted. The Court of Appeals acquitted, and the Court of Cassation also acquitted the accused because there was lack of procedural proof that this individual shared confidential information. And and there was a mismatch in the testimonials, etc., etc. So the Ombudsman couldn't prove it beyond reasonable doubt. So there were only procedural issues in cassation. In terms of the interpretation, legal interpretation of 182 was not on the agenda for the Supreme Court to interpret. There were no other cases received by the Supreme Court. Therefore, there was no legal position offered by the Supreme Court. When it comes to pretrial investigation bodies, well, you should, what to do with them? You should ask the prosecutor's office, because procedural monitoring during pretrial investigation is with them, because the court cannot really nag at the pretrial investigative bodies. There are some legal means that the defense side urges the pretrial investigators to take certain actions. You know, when they're sluggish, when they fail to act, there are certain means. And why does that happen? Well, I do not want to defend the law enforcement here. It's up to them to justify what they're doing, especially those who have the jurisdiction. Maybe the workload for the judiciary, and I hear different figures. They have several thousand proceedings per investigators in big cities. You know, if you do one procedural actions per each case, that still wouldn't be enough. Therefore, they had to prioritize. There's all adage. Only those cases progress that are either high profile or are complained about a lot. So I don't know why the progress during pretrial investigation is so slow, with the exceptions when there's judicial control exercised over them. When it comes to temporary access to patient confidentiality, there were certain cases that reached the Supreme Court, and you need to see the progress and the trajectory of legal positions by the Supreme Court. And here we're facing a system of problems, requiring medical documents, then providing the expert opinion. Third, the defense provides their own expert opinion, and the body that can appoint all that. Because, you see, the Supreme Court has made their positions. So if the information is confidential at the stage of pretrial hearing, it cannot be made available. Back in 2019, they constituted 4 serious procedural breaches. For example, when the medical records were not made available before the end of the court hearing. The Joint Chamber later looked at the following issues. The results of the expert opinion are open to the defense, but not the medical records. And then the Joint Chamber ruled, what is the evidence in the case? The expert opinion, and the grounds for that are the medical records. So if the medical records are still in secrecies, it means that they would have to close the case, because the only ground for ascertaining the death would be the medical expert opinion. And therefore, there's a baffling situation. We're looking at a case about serious bodily harm or causing death on the base. And because there's no access to medical records, we constitute that this is a procedural brief. The case is closed, and therefore no accountability for the accused. So in order to maintain the balance of interest, the Shared Chamber ruled that giving access to medical records is not so essential. the medical records were provided in full. That was the basis for the medical expert's opinion, so that the defense could have a look at these documents during the court hearing or the pretrial hearing, and so that the defense could make sure that these are the same records, because a party can motion for a different expert opinion to be appointed if they have doubts. Now, we really have an article about temporary access if the investigative judge provides the ruling, if there's a risk of destruction of the files. But there's also the Article 93 of Criminal Procedural Code. It says that the judge needs to call on to the public institutions to obtain documentations, i.e. sending the relevant requests. So, how to deal with this question? When we're talking about investigation on bodily harm or causing death, and when the investigators requests medical files, that is the base of the expertise for the reasons that bodily harm was caused or death was caused to the victim, it is crucial that the investigator demands not on the basis of temporary access, but demands that on the grounds of the investigator's request. Whose rights are protected? Because this document belongs to the victims, not to the accused. The victim's family have an interest in holding the criminals accountable. And we say, because the documentation was seized on the basis of not providing temporary access, therefore the results of the expert opinion is inadmissible. Well, who are we protecting here? The victim's interests, but as a result, we cannot hold the criminals responsible. So the question is whether this breach is significant, to what extent, and what it impacts. Has its influence on proof beyond reasonable doubt of the accused? So there is no must of requesting documentation through temporary access. The Supreme Court looks at every case separately. Why do you provide temporary access? It's a court ruling, and it checks the legality of providing access to this information. But in our case, when it's temporary access to medical records of the victims to defend the interests of the victim, do you need a court ruling here? Thank you, colleague. I have a few comments about it, because you definitely ask about the balance of public and private interests, and that's legitimate. It's logical when it comes to public interests in ascertaining the truth on the case. That is something I can understand. Today, however, we have a very clear norm, and maybe the Criminal Procedural Code or the CPC needs to be amended. Now, in my analysis of the criminal codes, I can see that the government has somewhat careless attitudes to patient confidentiality. There are certain provisions that, for example, a prosecutor can gain access to certain information upon petition. We need to change that. The cases that I pinpoint, it's about a disclosure of patient confidentiality, and it's in the criminal procedures. It's not the evidence is not just the conclusion of the medical expertise. What I think, the joint chambers said that the victim needs to provide medical records themselves. I second that. You don't need any additional tools for that. Pretrial investigative body has these tools because sometimes they cannot even seize the originals. They don't have the judge's consent if they need the original of the records. So I think the judicial control should stay inter alia to protect the interests of the individual, because in the future these materials stay in the case file, the criminal case for some reason, but they need to be returned. I think the judicial control would stay. Patient confidentiality is important. So, for example, I gave the documents to the court and it stays in the court, and I need the originals of these files, but the service provider needs it. So what I see is foot dragging in pre-trial investigation. This is bad, but there's foot dragging in courts as well. So my point is that the judicial control should stay. It's an issue of public interest. I understand that. The Grand Chamber of the Supreme Court said about a significant breach, but the patient confidentiality is the significant breach. So I think that we need to stick to the Criminal Procedural Code and the case law of 2019. And the law enforcement bodies, I think it's a subject for another discussion of the Ombudsman's office, that we keep this judicial control. I think that in part of the documents, the patient confidentiality was restricted. We have so many requests coming from other countries or for exchange. There are so many academic research that they want to change the information on genetic information, and it's not just my information, but the information of my family. It's a very sensitive field. The judicial control should be in place. It's not just about defending the victim's rights. We do that, but we want a more effective judicial control. And the law enforcement need to gain temporary access promptly. And then it comes down to not upsetting the balance. I don't think the balance is upset. We don't want any medical files remaining in the case files after the proceeding is closed, so that these medical records need to be returned to the service providers and are kept in line with the regulations, sometimes up to 50 years. As a practitioner, I am a part of various court proceedings. I would not remove the judicial control here. And I don't think it harms the victims. On the contrary, the judges say to people, okay, write that you do not prohibit them from reading medical records. Medical records are a separate procedural source of evidence, and there are documents and proof.
До нас, як до володільця персональних даних, надходить дуже багато запитів правоохоронних
To us, as owners of personal data, a lot of requests from law enforcement institutions comment. We understand that it doesn't matter who is protecting the interests of people, because the Code of Criminal Procedure has the condition relevant to personal data, and medical data, which is personal data, is contained in our database. What's also important, even despite the fact that we get rulings, a ruling has to be clear, easily understandable, and when personal data is required. We should also learn what kind of professional data has to be provided or from what register, because we get a lot of court judgments, a lot of rulings with a request to provide all the information we have from different registers. So that's an important thing to mention. We have to analyze every individual ruling, whether they correspond to the principles of data protection. So for the National Healthcare Service, it's important to get clear data either about the doctors or the patients. I agree with you. There are some requirements as to the elements of a ruling, and I keep asking law professionals that the rulings have to be composed in a very clear and concise way, mentioning specifically what information they need. And when you get the copies, you might get confused. I remember a case when a person was given all the test results, all the diagnostic procedures results, and all the other data. So we exceeded the limit of what the investigator asked for. And I think that it's not a good thing that in transitional provisions we have a segment related to medical secret. Thank you, dear colleagues. Thank you, dear experts, for finding the time to join this discussion. I think it is extremely useful because the results, the study findings could be read in the document, but today we got an opportunity to discuss the things we need to undertake for our future development, and it was a very timely discussion. Some people might not like the things we mentioned, but we need to undertake effective measures to protect human rights. If anyone has questions, please, you're welcome to ask them. Just turn on the mics. Good day, dear colleagues. Dear Irina, thank you for inviting me. I'm happy to join this, in my opinion, discussion of a global problem. We are currently in the last carriage, and the problem is moving forward on a very high speed. We should probably go back to the understanding of the three kinds of logistics in our state. There is war logistics, where we have a target and we don't calculate the resources. There is business logistics, where the main goal is money and profit. And it's a right approach because this money goes for the tax, is received from the taxes. And there is medical logistics. So the state has only these three kinds of logistics. And when we speak about personal data in medical area, for me, the key phrase was that it's the most precious currency of the 21st century. So our personal data is something that can be used to earn money. I suggest that everyone who's present here answers to the following question. First, who might need my personal data, my name, my surname, my phone number, and the address? Second question we have to answer is who might need my medical data, the state of your health, the medication you take, and your health conditions. And third question, who might need the information about your personal data and your medical condition? Does an effective state need medical information? Yes, because medical statistics allows the state to preserve its resource and direct it in the right area. For example, in some areas of a country, there may be a very high percentage of people who get cancer. Then the state might look into this area to find possible causes. And if we start investigating these cases, we might see that in some areas where few people get sick, a lot of people die, we might draw the relevant conclusions and take the necessary measures. So, your personal data can be used by an effective state willing to preserve its labor resource. And does a state, in particular the Ministry of Health and the National Healthcare Service, need your personal data for the statistics? No. So one of the key points which has to be well thought is delineation or distinguishing between medical information and personal data in the government system. Because it doesn't matter whether it's Maria or Petro got cancer. What the state really needs is information about their age, their area of living, and when they got sick. When I was the head of the committee of the healthcare, we were doing everything we could to preserve the personal data without giving access for the ministry. So the personal data of the patients was transferred to private companies. You remember about the 3 kinds of logistics I mentioned. So the state has to preserve its resource and the business has to get money. Is it possible to control the state and the business? Yes. Do we have judicial tools today? No, we don't, because if the information is leaked, no remedies are there. Of course, it should not be an imprisonment. We need to provide for financial sanctions for the cases of disclosure or leak. If we take back money from business environment for these cases of disclosure, it might work. We mentioned the consequences today, how we should fight unlawful cases, and let's think about prophylaxis. You all have an individual QR code today. I, as a medical worker, instantly think about the digital printers. So we all have codes, we all have personal data we use to identify ourselves in medical system. And the main thing is this identification. The state has to decide how personal data can be protected. What we cannot miss or lose is the fingerprint. That's something we can be used to identify ourselves while accessing medical electronic systems, and we basically will be able to prevent any leaks or disclosures. I remember the times when the medical management decided to use both the personal data and the medical information. But once again, I think that an effective state really needs medical information. At this point, I don't think Ukrainian state uses medical information effectively because we have a dire situation with demography. Then, as to the personal data, again, if the personal data and the medical data is combined, who might need it? Those who know your personal medical problems and want to sell something to you. So it works in the interest of business structures. Another thing I would like to draw your attention to is virtual medicine. As a doctor, as a practicing doctor, I work online in this virtual format, and I'm now suggesting to the Ministry of Health to coordinate between ourselves, because this process is not coordinated. And another thing I'd like to mention, it is something very personal. We have leaders of opinion in our country. What's their main task? If they are doctors, they have to raise awareness on a healthy lifestyle. And currently, Bogomolsky, Komarovsky, Bogomolets, and Mosov are used to sell information to people. You can even find advertising from these famous people. They just sell medication. We keep writing to the cyber police, opening criminal proceedings, but I am not successful in it. I cannot do something about that. From the point of view of preservation of safe information space, we need to do something about these people. Maybe they have to get sanctioned or pay a fine. But we get back to the main thing, the logistics, the military logistics, social one, and medical one. The solution is simple. Personal data and medical data have to be separated, and it is easy to do, completely realistic. Thank you for your comments, dear colleagues. Who else would like to take the floor? Are there any questions? Thank you, Olga, for giving the recipes already. I discussed it with the doctors who want to have another kind of authentication. I don't know, we will have even more requests if there are these novelties, because many doctors file complaints because of additional burden today. And You know that we have changes going on in the medical system. For example, I'm a lab worker in a medical institution, and I have an opportunity to see what surgery was done to a certain person, and I can do it. It works today. That's why I keep saying that if it's visible, who access this data, it will be beneficial for everyone. We are not looking for recipes today. It's a topic of a different discussion. And I think we already started discussing it. And I'm grateful to the Office of the Council of Europe and the Commissioner for Human Rights for taking part in this discussion. It is already something that will save us, and I hope we will go in the right direction, because everyone is already thinking about how we should develop, in which direction. And we should be very conscious of what we are sharing. We should be very careful. We probably have a lot of expectations from the Commissioner for Human Rights. You have a huge mission, and I would really like this office to have more tools in our country, because they were given some powers, but not enough. They need to have more tools to be more effective, because sometimes we think about whether they are effective with the current set of tools. So I'm very grateful to everyone. Yes, Helena, please. Thank you. It won't take long. Just one short remark. I really liked the discussion. Thank you for the study you conducted and presented. It really took into account the high standards of the Council of Europe, the current legal base, the achievements, the gaps, and everything was done in the light of the current practice. So thank you for explaining the civil code aspects. We cooperate and we get updates as to what amendments are suggested to the civil code. So we take note of everything. I'm happy to learn it, and I wanted to emphasize that what we currently see is that we have a new agent of civil, medical, and information relations. We have representatives of the patients and other people who might represent their interests. And actually, it was not regulated in the current legislation, even though we have options as to representation, and patients can use this provision. They can assign representatives to manage their medical data.
When it comes to our discussion, I think we need to name this individual, the individual authorized by the patient of age. authorized to give consent. Our legal thinking defines that things that are not written into the law seems not to exist. But given the above-mentioned discussions, we need to include that individual and write that into the law. I looked at the proposals from the Ombudsman. Page 6 does mention the individual authorized by other individuals to implement Part 5, Article 39 on the law of Ukraine on the principles of the legislation for the healthcare. If the patient dies, the family members or other individuals authorized by them have the right to be present. This is the only case where I found this authorized individual mentioned. The orders of the Ministry of Health do include such authorized individuals in case of an emergency, so it's participants of the civil legal relationship. So basically this is the representatives based on the verbal agreement, and this is the individuals that emergency medical services would go to or medical doctors would go to if there's an emergency. So they have to provide some medical information using the indicated phone number. So there would be a legal relationship that needs to be regulated somehow. And thus, a new participant to that relationship appears the so-called intermediary between the service provider and the patient, and in this information relationship as well, between the patient and the owner of the data, between the data subject and the service provider. There's an intermediary there, and it needs to be incorporated in the regulation. And also the technical equipment need to be written into that framework. Yes, this is the current problem. Thank you, colleagues. A comment. Article 8 on the law of the personal data protection does mention this other person. If I authorize people, it's always the question and a thorny point how exactly an individual can authorize. But when it comes to consent for medical intervention, there's a new player emerges in this market in terms of the agent. You need to treat this comprehensively. If we adopt a pocketed approach, changing bits here and there, we will run into the problem later. So, from your comment, I don't see, how does the government see it after codification, these foundations of the regulations? What would be their role? So, we have this social regulation concept. If we have a social code, then what happens to the medical? That would lead to further fragmentation. I think we need to stick with the main principles of the healthcare regulation and maybe amend them. I think these main principles have been tested and we keep amending them here and there, but there's an internal conflict within these grounding principles. So I think we need a new edition, and it would be quite fit, given the complexity of the subject, to have the healthcare code. Okay, on this optimistic note, we will wrap up the discussion. The official part draws to a close, and we will begin the unofficial. I extend my thanks to every in-person participants, to everybody who listened to us coming from the Ombudsman's office and the Council of Europe office, to all the listeners. I thank myself, the moderator. I'm grateful to everyone. I strongly believe that we will think twice before acting on our own privacy. And then regardless of the office that we hold, we will do utmost to protect personal data of people, because it's the Patient Safety Day. Everybody needs to be aware that any of us could potentially be a patient. Thank you, and until we meet again. And the Ombudsman Office promised to convene us again, don't you? I thank the Office, I thank the Council of Europe, and until we meet again.